Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky.
Bad things are going to happen.
You disrespect my authority.
That's Cartman, of course.
What the law says and what they should do are different.
Honestly, it sounds like squatters have more rights to be in a place than these kids are getting.
A brutal beating in Hazelwood captured national attention. A student was caught on video repeatedly slamming a classmate's head into the concrete, and that left her in a coma. Some politicians have called for the assailant to be tried as an adult. Well, who will decide and how? And the Innocence Project is suing Missouri Governor Mike Parson. They say he doesn't have the right to dissolve the board of inquiry that his predecessor convened to examine the innocence claims of a death row inmate. What will the Missouri Supreme Court say? These are important issues involving the justice system, and so we're lucky that today is our legal roundtable. 3 expert attorneys will help us make sense of these and many other items in the news. And joining me now in studio is Sarah Swadesh. She is a labor and employment attorney who's in private practice at the law office of Sarah Swadesh. Sarah, welcome back.
Thanks so much.
And we're also joined today by Javad Kazali. He's an attorney and founding member of the St. Louis firm Kazali Wersch. He's also a former federal prosecutor. Javad, welcome back.
Thanks for having me.
And also today, making her legal roundtable debut is Liz Lenevy. She is an attorney at the Simon Law Firm in St. Louis, where she specializes in medical malpractice, product liability, and personal injury. Liz, we're so glad to have you here today.
I'm so glad to be here. Thank you for having me.
So we're going to talk about that fight in Hazelwood, and of course, we're going to talk about the case against Governor Parson, which was recently heard at the Missouri Supreme Court. But before we get to that, on Saturday, Washington University here in St. Louis invited multiple area police departments to come to its campus, and then they ordered pro-Palestinian protesters who'd set up there to disperse. Well, 3 hours later, they started making arrests. 100 people were arrested. That includes 23 students and 4 faculty members. So this is a private university. There's no question WashU is private. Javad, is there any question as to whether the university had the right to do what they did?
I think the university absolutely had the right to tell people to leave, and they could enforce that. The issues that I think are causing a lot of people to stand up and say, wait a second here, is the amount of force used by the officers. I can just tell you that day, I went by the protest with my 13-year-old. She'd never been to a protest before. And it was calm. If anything, I would say it was one of the more understated protests I've ever seen. Our firm was very involved in Ferguson and Stockley. This was a boring protest. There were little kids walking around, and then we leave, and an hour later, you see these videos of a phalanx of police officers coming at people and dragging them and beating them. So, yes, the university had the right to do it. I think it wasn't the smartest idea. WashU's had a history of chancellors coming out and talking to people. There have been encampments on this campus a lot. You know, you had them during Occupy Wall Street. You had them here without any problems. The encampment wasn't anywhere near classrooms. They had the right to do it. The way that they did it is problematic in some ways. And then some of these disciplinary positions that they've taken against their faculty, their staff, their tenured professors, their students, I see some problems there.
Yeah, I mean, I'm glad you brought up these disciplinary actions that followed because there does seem to be consensus. You're allowed to tell people to disperse and you can enforce it if they don't. But then these 23 students, they were promptly suspended. They were ordered to get off campus. You know, I guess they were let out of jail on Sunday and they were told, hey, you have to get off campus by 8 p.m. Not just keep your person off this campus, but clear your stuff out. Liz, any thoughts on whether they have the right to do that if you have a tuition-paying student?
It's interesting because, you know, as Javad had mentioned, the university has the right to have people leave. It is, I'm not entirely sure about kicking out a student who has paid tuition. I assume that there is going to be some sort of, or there should be some sort of due process. I don't have a ton of experience in the civil rights world, and I'm kind of drawing back to when I was a student myself, working in the disciplinary proceeding. I was a student rep.
You were part of that judicial board.
Yes, I was always the sort of liaison for students as a student myself, and usually there is a matter of due process there. So I don't want to go as far as saying WashU is not within their rights to ask these students to leave, and I'm sure there is a lengthy student code of conduct that students are expected to follow, and they are able to understand if they don't follow that student code of conduct that there can be repercussions. But I would hope that WashU, as a place that would promote academic freedom and thought and discourse, would give these students proper due process.
So WashU actually has really good disciplinary procedures. I mean, I've looked at them. I'm a WashU law grad. We've been asked in multiple instances to look at some cases related to students. WashU's disciplinary procedures are really good, and they utterly abandon them here. They have procedures that talk about immediate suspension. Mm-hmm. Immediate suspension is a last-ditch effort, and in their procedures, it is very specific. This is for people who are a danger to themselves or a danger to others. I saw nothing that would tell me that these people were a danger to anybody. There's no videos that show that they were dangerous. So yes, I totally agree with Liz. If you want to put them through disciplinary proceedings, do it. Mm-hmm. Give them their due rights. But to say immediately we're going to abandon our rules that lay out, the rules are written for people who are sexual assault, people who could be shooting up campuses. The rules did not foresee this. They're making this portion of the immediate suspension up ad hoc.
And Sarah, they're a private university. Is that something they can do? Can they say, we're just throwing our rules out and that's it, we're kicking you off campus?
Well, I'm not in a rush to convict WashU on what they've done. First of all, I don't know who these 23 students are. And Javad may have seen a peaceful protest, but he didn't see the WashU administrators come up and say disperse, right? And so what he's described as some sort of peaceful sit-in, well, squatters are also a pain in the butt, right? And we have to remove squatters, and sometimes we remove them forcefully. And maybe they're not throwing bombs, and maybe they don't have weapons, but you still got to remove them. The students, the faculty, the citizens, the rebel rousers did not leave. If somebody walks onto my property and I tell them to leave and they don't, and they just sit down, I'm going to call the police.
It's also interesting. I mean, of the 100 people that were arrested, 23 being students, that leaves a whole lot of people who were not students. And there were only 4 faculty members who were arrested in this. These are a lot of people who maybe don't have any right to be on this campus.
And I would like to know more about what the 23 individuals did. Right now, I think there's an assumption by half of our population that these people did nothing and they were eating a ham sandwich. And I would assume that the other half of the population suspects that these 23 students were kicking, running, chasing, otherwise being antagonistic to the police who were asking them to leave. So I don't know what these 23 students did. So I'm not prepared to say WashU abandoned all of its policies. We don't know that. But I'm also not prepared to say that these students behaved appropriately. I simply don't know. But I think there's a rush to judgment.
So there are a lot of opinions about this going on online in addition to this panel. And if you want to join our conversation, phone lines are open. We're at 314-382-8255. That's 382-TALK. We are interested primarily in your legal questions. We are not going to solve any of the bigger issues here today with this particular panel, but you can give us a call. You can also send us a tweet at STL On Air. Gregory writes, quote, "If I choose to protest my employer and refuse to leave when told to, I should also expect to get fired. If what you are protesting is important, then you should be fine with whatever repercussions head your way." Javad, I'm going to turn this to you here.
So I'm going to push back on what Sarah said earlier. Other universities you have seen where they have picked out 1 or 2 people involved in protests and specifically said this person is being disciplined because they did A, B, C. Mm-hmm. The university put this penalty on every single student who was arrested. I totally agree with Sarah. They had the right to tell the kids to disperse and to arrest them. I don't have a problem with that. I do have a problem with some of the videos and the force that I saw, but putting that aside, the question is the disciplinary process. Mm-hmm. They can be put into a disciplinary process. No problem with that. The question I have is the immediate suspension. They've laid out a handbook that tells people they're accepting their $80,000 a year from each of these people. They're accepting their money for their dorms. They say these are the rules. And then I do not believe, after seeing dozens of videos talking, I do not believe that every single one of these 23 people did something that would be a risk to themselves or a risk to others. And when you see across the board wholesale collective punishment, because that's what this was, then I question whether that's the immediate suspension policy makes sense. If they want to put them through an academic code of conduct, I'm fine with that. Let everybody show us their hands. The university put out a ridiculous statement that said, we had intelligence that there was bad stuff going to happen. Let's see it, okay? But you can't just come out and say this afterwards to justify your actions. With the professors too, you had tenured professors who are banned from campus. These people have tenure. These aren't normal employees. Every university has this concept of academic freedom. And to do these things wholesale without due process seems draconian to me.
I'm going to go to the phone lines. Joe is calling here from Chesterfield. Joe, hi, you're on St. Louis on the Air.
Hi, how are you?
I'm doing great. I understand you have some thoughts on this issue at WashU.
Yeah, just kind of interested to get an opinion, but I guess one is if any of these students were living there or living on campus, don't they have some sort of a tenant protection from being kicked out, just carte blanche? That would be one. And then additionally, I just kind of a point I heard that, we remove squatters because they're a pain in the butt, but honestly, sounds like squatters have more rights to be in a place than these kids are getting.
Joe, thank you so much. You made two very interesting points there. That tenants' right thing, something I had not even thought about. Javad, any thoughts on that?
So one of the things that I think that the university has abandoned here is anytime anything happens at a university, the first statement that the university puts out is, the safety of our students is the most important thing to me. You notice that's not in any of these things. They came to these students, gave them 15 minutes with guards, told them to empty out their rooms. Some of these students don't have family here. Mm-hmm. Some of these students don't have the ability to get housing. I think the caller's right. There should be due process here. And the idea that you're throwing college kids that are within your care out on the street without giving them a hearing and before all of this doesn't pass the smell test. Now, the university is trying to claim that because they're a dorm, there isn't a landlord-tenant relationship. Mm. I don't know how far that's going to go, but I think the caller is absolutely right that before rushing to judgment on this, and I agree with Sarah, you shouldn't rush to judgment on any of this stuff. But when you put in these nuclear penalties, kicking people out of their dorms, giving them 15 minutes to leave, not knowing where they're going to end up, telling them they can't come back for their finals, and all this without any hearing, and then putting on top of this that you're going to treat them all the same without looking at them individually, I think the caller is absolutely right. There are problems here.
Something else that's been raised is for these 6 professors, 4 of whom were arrested, 2 of whom have been suspended but weren't actually arrested. They were told, this is a quote from the letter they got from WashU, quote, because you have been relieved of your job duties, you are expected to refrain from contact with students or work colleagues while on leave. I've had several people ask me, can they just do that? They've also kind of noted the language there. You are expected to refrain. Maybe that's not so much in order. Liz, any thoughts on whether WashU has the ability to tell a professor, you can't talk to your colleague, you're suspended?
I'm looking at Sarah over here because she does employment work. I mean, my initial thought is, yes, as the employer, they have that right, but I would like to give it to the expert.
Yeah, that's common practice. It's absolutely common practice. If an employee is suspended, they're told, don't contact your colleagues, don't come to the workplace. We're investigating whether you've engaged in sexual harassment. We're investigating whether you've engaged in some workplace bullying, whether you've engaged in some threat of violence. It is common practice to tell them, don't come to the job site until we tell you to. There's nothing out of the norm about
Is there
that.
anything enforceable about that? Say I'm suspended and I contact my buddy because I'm like, hey, this is really important to me to understand what happened from your point of view. Could they use that to say, hey, guess what? You're not just suspended, you're fired.
Absolutely. Absolutely. It happens all the time. It happens all the time. I believe there's something going on with the Tower Grove. There was some 3 manager employees
At the Tower Grove Park.
At the Tower Grove Park, and maybe one, or I don't represent any of the individuals, but 1 or 2 were maybe placed on suspension, or they weren't even placed on suspension. They said, "Hey, work from home while we're looking into a matter," and he came into the office to get the mail, and they said, "We told you not to come. You're fired." Now, that gentleman has his own kerfuffle, and I don't know the ins and outs of it, but it's common practice to say, if you're suspended, don't come to the job site, don't contact your colleagues, because what the employer is really trying to prevent is undue influence. You're trying to prevent additional coercing. If you've been suspended, don't talk to your coworkers, right? We don't want you coercing. We don't want you digging for information. We don't want you tainting witnesses or an investigation. Stay away until we call you in. I'm not offended by it.
Jawad, are you offended?
I like to look at the way an employer acts and see how they are applying their policies. The Riverfront Times last year reported about a professor at WashU being accused by multiple Asian students of sexual harassment. That teacher is given due process, is still allowed to teach right now and be within the proximity of students. The university decided this professor, who has claims of sexual abuse, should be given all the due process in the world. Abusing your students is not bad enough that we need to take immediate action. But standing near your students as they're protesting with no allegation that you touched anybody, no allegation that you beat anybody, that is so bad at WashU that we need to make sure that you're off campus. So according to what I can see, if I'm on this side, I go, WashU says, professor sexually assaulting students, not bad enough for us to do something. Professor standing by students in solidarity to watch something, that's the worst thing you can do. You should never come back to our campus. How dare you?
Sarah Swadesh.
I would be curious. I don't know about the professor sexually harassing students. I'm, of course, appalled by it. But I would be curious, was that professor tenured?
Yes.
He was.
And
So-
one of the professors who was suspended was tenured.
So
And
one of them was,
One.
not the other 5. Well, the other 5 don't have tenure rights, right? So perhaps WashU should have exercised a little more discretion, and the one who was tenured perhaps pulled that person out and not been immediately suspended. But tenure is the closest thing you can get to it is like a union, union rights. They can only be fired for cause. They can only lose their tenure for certain reasons: death, retirement, request to go part-time, or for some other for cause, theft, embezzlement, failure to do your duties, that sort of thing. So the professor who was not removed after allegations of sexual harassment, I don't find surprising. I find it disappointing, but not surprising. And perhaps WashU painted with too broad a brush as to these 6 professors, and perhaps only should have suspended 5 of them. But either way, Javad is right. They do have a robust tenure policy, and the one professor who's tenured and suspended as part of this protest, he or she can grieve his suspension through their committee.
They're going to have a lot more recourse here. Okay, we're talking today to our legal roundtable. That is Sarah Swadesh. We're also joined by Javad Kasali and Liz Lenevy. We need to take a quick break here. When we come back, we're going to talk about a lawsuit against Governor Mike Parson that it came from a man on death row. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
Welcome back. So the state of Missouri, they have been maintaining a steady pace of executions. A lot of states have been pulling back from capital punishment. That is not true of the state of Missouri. Another man on death row, Brian Dorsey, was given a lethal injection earlier this very month. Now, the Missouri Supreme Court also heard a case this month involving a man named Marcellus Williams. He's been on death row since 2001. He came within hours of being executed in 2017. But instead, Governor Eric Greitens appointed a board of inquiry to examine Williams' claims of innocence. This was back in 2017. Fast forward to today. Liz Lenevey, what brings us before the Missouri Supreme Court this month?
So the issue now is that Governor Mike Parsons is seeking to dissolve the board that Governor Greitens in 2017 put together. That board, he had the statutory right to create that board to look into this case. That board is made up of 5 federal judges, so certainly people with lots of legal experience, lots of legal wisdom to look into whether or not this man was prosecuted with the necessary evidence, or whether his conviction should be vacated. The matter now is whether or not Governor Parsons has the right to dissolve the board. The statute, in reading it, at least in my interpretation, having gone through the briefs, it seems very clear that absolutely Governor Greitens did the right thing in appointing this board, but I don't see where the legislator gave clear authority for Governor Parsons to now take that apart. And when reviewing the briefs, the attorneys representing Judge Walker out in Cole County, who had denied the governor's, the attorney general's motion to dismiss, I thought that they did a really great job of really keeping this a narrow issue of saying, like, let's look at what the legislator wrote. The clear language of the statute does not give Governor Parsons this right.
Maybe it's not as simple as saying that a governor created it, a governor can dissolve it. Sarah, what do you make of this case?
The arguments in the briefs reminded me of South Park, and I'll botch the quote, but there's one little character who's like, "You disrespect my authority."
That's Cartman, of course,
right? Because the governor is saying, "I have the absolute right to do what I want with clemency," and the Midwest Innocence Project is saying you don't have the authority, and they're arguing about separation of powers. Can the court review Greitens' executive order? Can the legislature overrule? It's a huge turf fight. But at the end, so the law doesn't specify what the board has to be, how many people are on it, who's composed of it, how long the board can assess and weigh the evidence, and I think the statute or the Constitution doesn't say anything about dissolving the board. And so I found this absolutely interesting. And so I got in there and started doing research, and I found a case called William Bolick. He committed a robbery. This is 1983, 85, committed a robbery in Kansas City. He's driving to Thayer, Missouri, which is my hometown. On the way there, he's having a discussion about killing witnesses, and he shoots a woman in the face so that she cannot be identified. He's charged with murder. He's convicted of murder, and he makes a clemency request to Carnahan. And these clemency request boards have only been granted 3 times. Carnahan grants it based on ineffective assistance of counsel. Carnahan dies in a plane crash, and the board never made a recommendation about what to do. The next governor came along and said, well, I don't know what to do. I think the executive order stands. The state of Missouri, who's, shoot first, ask questions later, says, we want to kill him. And so they brought a proceeding in state court, went up to the Missouri Supreme Court, and the Missouri Supreme Court said the executive order is clear. It says, I shall make the determination on clemency. And the Supreme Court said, we can't change the language of executive orders. One governor can't do it to the next order. And so I looked at Greitens' order, and it says, shall make a board, shall make findings, shall make recommendations. This inquiry board never did those things.
They have not made
They
any
have never done it.
recommendations.
And so I don't think Parsons can come in and dissolve it. If I had been Parsons' counsel, I would have said, let's amend it. Let's not change it. Let's put a time limit on it. Let's say they have to make a determination by X date. They have to make a report by X date, and they must give it to me by X date. I would have suggested he amend it, not try to dissolve it. But Missouri's always in a rush to kill people. So
Well, that is a
he
good
didn't
summary
wanna wait.
of Missouri. And I got to say, that history there, this suggests that he can't just dissolve this board. Do you want to argue with Sarah on this? I know you guys were enjoying arguing earlier.
Outside of Sarah's love for WashU, we totally, absolutely agree on this. There are two things that we're missing here. Number one, I don't understand what the governor's end game is here, because
Is it his end game execution?
right, but it's very clear. Once the board issues their decision, the governor's not bound by it. The board could come out and say, we believe this person is absolutely innocent. And the governor can say, I don't. Now, there's two, and what Liz brought up here was the process here. Mm-hmm. What's lost in here is the facts of this case. And there are some pretty interesting things here. There is no evidence at all, physical evidence linking Marcellus Wallace to the death of Felicia Gale. The only two things are an ex-girlfriend who claims that she heard him say something and a jailhouse snitch. The other thing is that this came out of Wesley Bell's office. And Wesley Bell's office has filed briefs in this case. And there was one paragraph in one of these briefs that was kind of buried in there that jumped out to me. And Wesley Bell's office, in arguing for a full investigation into whether the right person was convicted here, wrote, additionally, the prosecuting attorney is undertaking additional investigation related to an alternative perpetrator of this matter that may confirm or deny the involvement of a person other than Mr. Williams in the crime. That additional investigation will involve forensic testing, and other investigation will take some time. Reading this tells me that there's a belief that not only does Wesley Bell's office think somebody else did this, but they may have an idea who it is.
Yeah.
So why are we rushing to kill somebody when a possible real perpetrator is out there? Because in the end, isn't the whole idea here to make sure the right person is punished? So this is where it doesn't make any sense to me at all. If everybody's saying, hey, let's hold up and look at this, especially on a case with no physical evidence and jailhouse snitches, why is the governor rushing to do this other than to just increase his body count?
And we should note here, Javad referenced what St. Louis prosecuting attorney Wesley Bell is up to here. He has filed a completely separate lawsuit here. He is attempting to vacate this conviction using the new state law that allows prosecutors to get involved if they feel like an injustice has been done. And so there's this whole separate question here of whether or not this Marcellus Williams could be innocent. That is also sort of, the Board of Inquiry has been looking at this since 2017. Now you've got the prosecutor also looking at this, and yet you have Governor Parsons saying, hey, full speed ahead. Liz, what do you make of that?
I mean, I agree with Javad. I don't understand the rush to execute someone. Obviously that is, you can't undo it, right? Once the toothpaste is out of the tube, you can't unkill a man who's been wrongly convicted. And I certainly think that reflecting on this country's history of wrongful executions, in particular targeted against Black men in this country, I would like to see the governor execute a little more restraint and let the process play out, especially because now not only are we fighting this, in the Attorney General's office, but that really interesting tidbit that Javad has pointed out, there might be someone out there, and I think
guilty of murder.
Who's guilty of murder, and I think that if it's interesting because when I read through some of the statements by the governor's office, his reasoning for trying to undo Governor Greitens' executive order was, it's been enough time that we need justice for the victim's family. Well, if it's really about justice for the victim's family, don't you want to ensure that you're convicting the right person. And if there is evidence that indicates that it's someone else, then isn't it the right thing to do for the victim and the victim's family to make sure that there's no stone left unturned?
Sarah?
My assumption is this Board of Inquiry had no plans whatsoever to make a recommendation. It's been 7 years. It's my assumption they got the commandment appointment from Greitens. That meant he was open to the idea of clemency. Greitens is gone. Parsons is there. Parsons is I think he was a sheriff before he became governor. And the board says he's not going to listen to what we say. We're just not going to make a report. And
You think that's their way of almost saving Marcellus Williams'
yes,
life? Oh,
I
interesting.
do. That's why if I were Parsons' counsel, I would have said, let's not dissolve it. Let's amend it. Let's put some bookends. Let's put some time frames on it. And by the way, I mentioned Mr. Bolick. I checked yesterday the Department of Corrections website. He is still alive and in prison.
Wow. That's some interesting Missouri history there. That is yet again another reason why I love this legal roundtable. I learn something new every time we do it. Here's another high-profile case I want to just briefly touch on today. This involves a fight in Hazelwood. A young student named Kaylee Gain was beaten into a coma. This beating was severe. It was captured on video. This became an international incident. Everybody was weighing in on this, sometimes in very appalling ways. Now, the assailant of this young girl, Kaylee Gain, is a 15-year-old girl. The victim's family wants this assailant tried as an adult, and that this would leave juvenile court, be handled by the St. Louis County prosecutor, Wesley Bell. Now, apparently, this decision is going to be up to a single judge of whether or not that happens. Javad, what is this judge supposed to be looking at as they make this decision that could have a major repercussion on this young girl's life?
What the law says and what they should do are different. I think Sarah can talk more about the specific statute here. Missouri's got a weird statute here that basically makes you look at what the person was charged with. And what they're charged with can help determine that. What we really see across the country on charging juveniles as adults is how mad people are. The worse the crime is, the more there's press around it, the more likely and the bigger push there are to charge the person as an adult. Okay? This is a heinous crime. Awful.
Yeah.
The assailant's 15. Okay, I've got a 13-year-old. She hangs around with 15-year-olds. Not a single one of these 15-year-olds that I've ever seen has the mental capacity of an adult. They can't have a full conversation. The question should be, do you have the mental capacity of an adult? Charging a child as an adult should be a very rare thing to happen. It should be something that happens in those cases. And there have been cases where you show a kid is like a gang leader and he's running a full organization and he's doing things that are beyond their age. This is a 15-year-old who was in a fight. Mm-hmm. This person should be punished, but there's not a single thing that I've seen that would lead me to believe that this 15-year-old has the mental capacity of an adult. I mean, for boys, we know that the mind isn't fully formed until age 25. For girls, it's earlier, but it's still in the 20s.
It's not 15.
It's not 15.
Sarah?
Sure. The statute Javad's referencing is 211, and there are actually 10 factors that are taken into account. And one of the factors Javad is citing is included in the statute. Javad just puts more weight on it than the other factors. And so some of them are the seriousness of the offense, the viciousness of the offense, whether the offense was to property or person, whether it was repetitive, meaning recidivism, the record and history of the child, their intelligence, their emotional health, their intellectual health, the sophistication, maturity of the child. That's sort of what Javad's getting to. The age of the child. Was it a 12-year-old who shot somebody, or was it a 17-year-old who shot somebody? But they also look at, does the child have a network? Do they have a community? Do they have a church? Do they have a school? And the last thing they look at is the racial disparity. I think we all know that people of color are charged with higher offenses, and I would assume, I don't do criminal law, but I would assume that people of color also are more likely to be charged as adults than children. So
in Missouri, that's true.
And so I think Javad has correctly identified a factor, but there are actually 10 factors, and it's a big, complicated matrix, right? And the judge decides, but before the judge decides, the juvenile department and officer actually puts together a report, a very comprehensive report that goes through all of these factors, and then the judge decides. I don't think it's the judge just sitting there hearing 10 minutes of evidence and makes a decision. I don't think it's as easy as Javad, where we should almost never charge children as adults. I would disagree with that, but I certainly think when it comes to sentencing after somebody's pled or after somebody's been convicted, that's a really difficult decision. And I think whether to charge them as a juvenile or an adult is also those are probably the two most difficult decisions, I would assume, for judges.
Yeah, I mean, thinking about what the judge has to deal with in this case, this is such a high-profile incident. Liz, I know your firm does a lot of these kind of high-profile cases. We're seeing these big headlines. Do you think that can't help but get under a judge's skin where they're thinking, oh boy, people are going to be paying attention to this one?
I certainly don't want to speculate what the judge in this case may be thinking, but I have to imagine that he is approaching this with certainly with the knowledge that not only is the entire city, the entire state, but the entire country is looking to see what his result is going to be. I do also think, though, that because this case involves both a minor victim as well as a minor defendant, that there's just a lot of information that...
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.
We may not be privy to as the public that the judge and the courts are going to know about, and that's something to remember as well, is that we don't necessarily have all of the information. We have what we've seen on social media and what maybe folks like us are talking about right now, but the judge is coming at this from a very different perspective with a lot more information.
So I agree that there are multiple factors that Sarah laid out, and a judge has a hard time doing this. My position is a lot of these factors are ridiculous and shouldn't even be taken into account. Okay, the seriousness of the crime. I mean, I get that that's what the law says,
it's
but
just BS, Javad. So we shouldn't take into account racial disparity.
No, we
You're
should.
right.
No,
and we shouldn't take in their maturity. You're right.
No,
and we shouldn't
those are
take
the
in the
ones I agree with.
recidivism. These are all
first of all,
great factors.
No, they're not. The seriousness of the offense has nothing to do with whether the person is an adult. Okay, whether it was against a person or a property has nothing to do with whether they're an adult. The one I love, this is my favorite though, this is whether the child can benefit from the treatment or rehabilitative programs available to juvenile court. This is conceding here that our normal jails where we could possibly throw this 15-year-old can't rehabilitate this person. We've given up on rehabilitating people in our normal jail. Any 15-year-old is going to be in a better situation to be rehabilitated when they're in a juvenile system than being thrown into a prison with 30-year-old felons. So my position is yes, those ones that you pointed out, racial disparity is important. I haven't seen a case where a judge has taken that into account. The other ones, I agree with. The maturity of the kid, that's what this should be about. The intellect of the kid, the sophistication of the kid. All of the other things should be irrelevant to finding whether a person has the mental capacity to be an adult.
Sarah, I'm going to give you the last word on this subject before we have to take a quick break.
I think it makes a huge difference. Is the injury to the property or a person? Graffiti. Nobody wants a 17-year-old charged as an adult for graffiti because they wrote "school sucks," right? It's a harmless offense because it's to the property. I think all of these factors are incredibly important. I think the juvenile officer who does an assessment and puts them together is doing a fine job. I think these are great.
We're talking today to our legal roundtable. That is Sarah Swadish. We're also joined by Javad Kazali and Liz Lenevy. We need to take a quick break. When we come up next, we're going to talk about a lawsuit filed by the parents of a firefighter who was killed in a tragic incident 2 years ago. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky, and today for our legal roundtable, today that involves Javad Kazali, who's a former federal prosecutor and a founding member of the St. Louis firm Kazali Wersch. We're also joined by Sarah Swadesh, a labor and employment attorney at the law office of Sarah Swadesh. And today, making her legal roundtable debut is Liz Lenevy. She's an attorney at the Simon Law Firm. She specializes in medical malpractice and personal injury and product liability. And Liz, I'm very glad you're here with us today because there's kind of a high-profile lawsuit here that involves your area of expertise. This one is just heartbreaking to me. This is St. Louis firefighter Ben Polson was killed 2 years ago while fighting a fire in a vacant home in North City. The ceiling collapsed. And I was thinking at the time this happened, okay, this is just one of these tragedies where no one can really be held accountable for this. It's a vacant home. You can't sue the homeowner. This is a firefighter. He rushed in, answered the call of duty. Here now we have a lawsuit against 3M. Can you tell us a little bit about what's at issue here?
Yes. So you're right, Sarah. This is a tragic case, and the facts, just knowing what we knew to begin with, were already sad. But then reading the allegations made in the petition were pretty infuriating for me because it seems like it was such an avoidable and overall just senseless tragedy. But the allegations made in the petition were that these defendants, which is 3M, one of their subsidiaries, and then an additional defendant that looks like it was in charge of purchasing and procuring this particular product, which what was at issue was a self-contained breathing apparatus and personal safety system. And basically, it's the machine that gives the oxygen that these firefighters need to rush into these buildings, but also an alarm system so that if they are in need of rescue, their fellow firefighters are able to find them timely, because we know in these situations every second counts. And so the allegations were that not only did firefighter Polson's breathing apparatus fail, but that alarm also failed. And so he was in one part of the house. They were capable of rescue, but because the alarm did not properly locate him and alert his fellow firefighters, they were not able to rescue him in time. And that's really important because we have to show, as a plaintiff, we have the burden of showing that whatever the defendant's negligence was, whatever the defect was, it ultimately made a difference. It was the cause, the causal connection between the negligence and the damages in this case. So looking at a sort of a 30,000-foot view of a product liability case, what does that mean? Well, that means the plaintiff has the burden of showing in Missouri, first, that the product was being used as it was intended. I don't think that they're going to have any problem proving that. The bigger issues will be that they will need to show that the product was somehow defective. And there's various ways to show that a product may be defective. And then again, that causation, that whatever that defect was, that it then led to the damage in this case, which was for firefighter Polson's case, his loss of life, unfortunately. And so looking at these particular companies and this particular device, there has been multiple litigation prior to his death, not just prior to the filing of this lawsuit, but I think back in 2016 there was a New York case which found that the specific defect, a cable had melted, like something that was very necessary for this device to work. And you know that these devices are going into very severe environments. You're rushing into fire. So you know that if you're going to create a product that firefighters are going to rely upon, they need to be in safe, effective working order. And also that's how you market this. And so there's also, in addition to a defective product claim, there's also allegations of failure to warn, meaning that these defendants did not properly warn of the potential failure of the product. So how are they going to go about proving this? Well, we're very early on in the litigation. I looked it up. I don't even think the defendants have responded with answers yet. But ultimately, it's going to come down to probably lots of expert testimony, and these folks, experts will be brought in to testify to what exactly is the industry standard for these types of products and what should have been expected of them.
Sarah?
I see this as a seatbelt case. I mean, there have been problems with this machine not working. I think the case Liz was referring to in New York was back in 2007, and a firefighter got lost in a bowling alley that was burning. the machine didn't work. It didn't alert the other firefighters where he was located. He also died in a similar circumstance. This is a seatbelt case. This defendant is going to get hit with huge punitives, and they're going to be told, until you fix this, until you make it right, every punitive is going to get bigger and worse. I don't know how this defendant let it get to litigation.
And yet here we are. We're going to be watching this one as it plays out. I know a lot of people in St. Louis are. This was such a tragedy that happened to this young man. Javad, we have just a few minutes left here today, but I know top of mind for you is the latest at the St. Louis City Justice Center, and I can see why. Can you give us the short version of this very long saga of, frankly, mismanagement?
I mean, we have dozens of issues at the Criminal Justice Center in St. Louis that we've been seeing. People getting beaten, not getting food, not getting their access to medicine. I mean, they've even come out and said that they're trying to sign a contract now to hopefully put a vendor finally in place to get medicine to the detainees. We've seen this. But what really blew up here is Sue McGraw, who, just to be clear, I've got some cases that I'm doing with Sue as co-counsel, but she is a professor at SLU Law who is just one of the criminal justice heroes in this town. She had a client who is paralyzed, and he was not getting access to the bathroom, to the shower, to anything. And she complained about it repeatedly. And she takes a picture, finally, of him on the ground with poop on his pants, and she releases that to the Riverfront Times. Immediately, instead of saying, oh my God, the city goes, why did you do that? We're going to punish you, lawyer. Sue runs to court. The judges come back and say, no, you have to take care of these people. Then subsequent to that, the jail put in all of these harsh rules for being able to visit your clients. I have represented some people. I've been appointed to represent some people who've been accused of some of the worst things in Missouri. But I always get access to my client. In St. Louis County, I go into a room with my client. I can hand something to my client.
If they need to see paperwork, you can let them see that.
The city jail has stopped allowing that to happen because some of their own employees were bringing drugs into the jail. And instead of just properly searching the attorneys, they put all these draconian measures, including not allowing attorneys to pass things. So this ended up in front of Judge Hogan, who is the presiding judge in St. Louis Circuit. And she issued a pretty damning order to the jail that says you can no longer limit attorneys on how they meet with their detainees. You have to let them use their cell phones. You can't prohibit them from passing papers. And what does the city do again? They say, we're going to ignore a judge. There's no transparency anymore here. The amount that the city jail is covering up is outrageous. And for them to tell a judge to screw off is real bad.
So we have 30 seconds left here. Javad, do we have recourse if they're ignoring the judge's orders?
I mean, the judges have recourse. The bad things are going to happen. Lawsuits are going to come. And these are the types of things that end up paying for my kids' college. Because the city keeps doing terrible things. They know they're doing this. And they're just going to waste taxpayers' money that are going to go to civil rights attorneys like this. This is basic. Let attorneys meet with their clients.
So you heard it first here on St. Louis on the Air. Bad things are going to happen. Javad Ghazali, always a pleasure to have you here. Thank you for joining us. And Sarah Swadish of the Law Office of Sarah Swadish, thank you for joining us.
Thank you.
And last but not least, Liz Lenevy, thank you so much for joining us. I hope we can get you to come back.
Absolutely. Thank you.
And Liz is with the Simon Law Firm, making her Legal Roundtable debut today.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
St. Louis on the Air proudly supports local artists by using music from Life Creative Group.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.